Nothing is more natural than when the state begins to evolve out of society. The law of the state should, in respect of its material contents, be in great part modeled upon and coincident with the customs of the society. When the state takes up the function of administering justice, it accepts as valid the rules of right already accepted by the society, of which it is itself a product, and it finds those principles already realized in the customs of the realm. And these words were said by Salmond. So I want us to discuss the importance and the place of custom to the body of law in Kenya in connection with that statement by Salmond. Now, the statement by John Salmond reflects, the jurisprudential idea that law does not emerge in isolation, but law evolves from custom, it evolves from values, it evolves from the practices of society. Salmon's assertion aligns with the historical school of jurisprudence, especially the ideas of Friedrich Karl Vaughan, who argued that law grows organically from the spirit of the people. And this suggests that custom is not merely a social practice, but a foundational source of law. You see, in Kenya, custom occupies a central place in the legal system. Although the modern Kenyan legal order is largely constitutional and statutory, customary law remains, a recognized source of law, especially in matters of family, in matters of marriage, in matters of succession, in matters of land and community relations. So that the place and importance of custom in Kenya can be understood from constitutional, from statutory, and judicial perspectives. So I want us to look at the meaning of customary law. You see, customary law refers to rules of conduct developed through long usage and accepted by a community as binding. Sir Henry Maine described law as evolving from custom to codification, so that custom becomes law when it is certain, when it is reasonable, when it is continuous, and when it is accepted by the community. In Kenya, customary law is part of indigenous legal systems. In fact, customary law predates colonial law. Secondly, I want us to look at the constitutional place of custom in Kenya. Now, the first thing when it comes to the constitutional place of custom in Kenya is the recognition of custom under the Constitution. You see, the Constitution of Kenya recognizes culture as the foundation of the nation. In Article 11, culture is recognized as the foundation of the nation and cumulative civilization of the Kenyan people. So that this elevates customary practices in Kenya. In Article 44, every person has the right to participate in cultural life, so that custom is part of cultural identity. In Article 159(2)(c), courts are encouraged to promote traditional dispute resolution mechanism, so that this constitutionalizes customary justice. However, customs must not violate the Constitution. Second, when it comes to constitutional place of custom in Kenya, there is the idea of, number one, constitutional supremacy over custom. And Article 2 makes the Constitution supreme, so that any custom inconsistent with the Constitution is actually invalid. A good example is discriminatory inheritance customs. Thirdly is the statutory place of custom in Kenya. Now, the first statutory place of custom in Kenya is the Judicature Act, Cap 8. So that Section 3.2 of the Judicature Act recognizes African customary law in civil cases where one or more parties are subject to the African customary law, so that it is applicable if it is not repugnant to justice and morality. Now, this is the statutory foundation. Now, the second statutory place of custom in Kenya is the Law of Succession Act, so that custom may apply in succession matters in limited context. The third statutory place of custom in Kenya is the Marriage Act of 2014, which recognizes customary marriages. And you see, this formalizes, customary unions in Kenya. The fourth statutory place of custom in Kenya is the land laws. You see, the community land system in Kenya reflects customary tenure. In fact, the Constitution of Kenya recognizes community land under Article 63 of the Constitution. Now, let's look at the importance of custom in Kenyan law. Now, the first importance of custom in Kenyan law is that, number one, it is a source of law. You see, custom is an original source of law. Historical schools support this idea. In fact, Friedrich Karl Van argued that law grows from social practices. If you look at the case of Ernest Kinyanjui Kimani versus Kiganga Muiru, the facts of this particular case were that the dispute involved, a parcel of land in Kenya. And the appellant, Ernest Kinyanjui Kimani, claimed that he had been gifted the land by his uncle, Kiganga, under the Kikuyu customary law. The respondents challenged this, asserting that no such absolute gift had occurred and that Kimani had no legal title to the land. Now, the trial magistrate found that while Kiganga had granted Kimani access to the land, this grant only established him as a muhoi, that is, a tenant at will or occupier, rather than an absolute owner. So Kimani appealed, arguing that the magistrate had incorrectly interpreted the requirements for a valid gift under customary law. And so the central issue was not just the land ownership itself, but a procedural question, and that is, how should African customary law be established and applied in a court of law? And is customary law a fact that must be proven by evidence? Or is it law of which a judge can take judicial notice? And the Court of Appeal for East Africa dismissed the appeal, affirming the trial magistrate decision. And the court held, number one, customary law as a question of fact, where customary law is not notorious, that is widely known and previously established by the courts or documented, it must be proved as a matter of fact. The second thing was the burden of proof, so that the party who relies on a specific rule of customary law, in this case Kimani, carries the burden of proving that such a rule exists and applies to the circumstances. So the key principles established, number one, was proof by witnesses, so that since customary laws are often unwritten and vary between communities, they must generally be established through the evidence of experts or witnesses, such as, the village elders who are familiar with the tradition. The other thing was judicial notice, so that a court can only take judicial notice of a custom if it has been rendered notorious by frequent proof in previous court cases or is clearly documented in recognized legal text. And the other issue was also the repugnancy clause, so that while not the primary focus here, the case reinforces that customary law is applicable only as long as it is not repugnant to justice and morality or inconsistent with written statutes. So the principle here is that custom creates, legal rights. The second importance of custom in Kenya is the preservation of cultural identity. You see, customs protect indigenous identity. In fact, law without custom risks cultural alienation. If you look at the case of S.M. Otieno, which is a burial case, that is Otieno versus Ougo, the facts of this case were that there was a dispute over the burial place of a man called Otieno. And the issue was whether Luo custom governed burial. And the rule is that customary law governs personal law. And the application was that the court upheld, the Luo custom. And the conclusion of this particular case was that the burial followed customary law. The significance of this case is that custom defines identity. Now, the third importance of custom in Kenyan law is dispute resolution. You see, traditional dispute mechanism reduce litigation, and this is recognized under Article 159 of the Constitution. And a good example is the elders, council, and also the clan mediation. Now, the importance of this is access to justice. Now, the fourth importance of custom in Kenya is the regulation of family relations. You see, custom governs marriage, custom governs dowry, it governs divorce, and it also governs child custody. If you look at the case of Hoten Shia Wanjiku Yawe versus public trustee, the facts of this particular case were that whether customary marriage existed without a ceremony. And the issue was, can long cohabitation imply marriage? And the rule is that there is a presumption of marriage. And so the application of this case was that the court inferred marriage, so that the marriage was actually recognized. And the significance of this case is that custom shapes family law. Now, the fifth importance of custom in Kenyan law is succession and inheritance. You see, custom regulates inheritance in communities. If you look at the case of Rono versus Rono, the facts of this particular case was that customary inheritance discriminated against daughters. And so the issue was whether discriminatory custom could stand. And the rule is that equality overrides discriminatory custom. And the application of this particular case was that the court invalidated discrimination. And so the conclusion was that there was equal inheritance. The significance of this case is that custom is valid, but subordinate to constitutional equality. The fifth importance of custom in Kenyan law is judicial treatment of custom in Kenya. You see, courts apply custom where it is proven. The requirements are that for courts to apply custom, it must be proved. If you look at the case of Ernest Kinyanjui Kimani versus Muiru Kiganga, it was established that custom is a matter of evidence. Secondly, for courts to apply custom, it must pass, the repugnancy test, so that custom cannot offend justice or morality. If you look at the case of Mari Gisese Angoi versus Daniel Osengo, the principle behind this particular case was that unfair custom may actually be rejected. Thirdly, for courts to apply custom, it must not conflict with statute. You see, statute usually prevails. If you look at the case of Rono versus Rono, the Constitution overrides, discriminatory custom, as was seen in the case of Rono versus Rono. Now, let's look at the challenges of custom as law in Kenya. Now, the first challenge of custom as law in Kenya is uncertainty. You see, custom is mostly unwritten. Now, because of its unwritten nature, there are usually different interpretation which may actually arise. So the challenge is that it can cause a lot of legal difficulties. And the second challenge of custom as law in Kenya is the conflict with human rights. You see, some customs in Kenya discriminate, and good examples are gender inequality and also widow inheritance. If you look at the case of Rono versus Rono again, custom was limited by the idea of equality. The third challenge of custom as law in Kenya is diversity of customs. You see, Kenya has many ethnic groups, hence there is no uniform custom. So the challenge normally is fragmentation. The fourth challenge of custom as law in Kenya is modernization, so that urbanization has weakened, traditional customs. Now, remember, custom evolves. So the challenge is usually, identifying, authentic customs, especially in this age and time. Now, I want us to carry out a critical evaluation of Salmon's assertion in Kenya. You see, Salmond is substantially correct that the Kenyan legal system, reflects societal customs. And the good examples are marriage, burial, land, and dispute resolution. However, modern constitutionalism modifies custom so that unlike traditional societies, modern Kenya subjects custom to constitutional scrutiny. Thus, custom remains foundational but not supreme, in that custom informs law and the constitution controls custom. Hence, this reflects, legal pluralism, so that Kenya operates a plural legal kind of system where you have constitutional law, you have statutory law, you have common law, and you have customary law. So the conclusion is that custom occupies an important place in Kenyan law as a historical, as a cultural, and practical source of legal norms. It regulates, social life, it preserves identity, it resolves disputes, and it also informs formal legal systems. So Salmon's assertion remains relevant because much of law originates in social customs. However, in Kenya, customs operate within constitutional limits, so that the Constitution of Kenya ensures that custom must align with human dignity, it must align with equality, and it must also align with justice. Therefore, custom remains vital but subordinate to constitutional supremacy. So the place of custom in Kenya is both foundational and evolving, making it indispensable to understanding, the country's legal system. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.